Good afternoon and welcome to you all. It is nice to see such a good turnout today. My name is Irene Sher, Law Librarian. We are delighted to have Mr. Justice Bokhary with us today to speak on human rights. Justice Bokhary is no stranger to most of us here. He is one of the founding judges of the Court of Final Appeal and served as a permanent judge of the court for 15 years. Since 2012, he has been a non-permanent judge of that court, i.e. he is now happily retired and enjoying life. He has many honors and awards that reflect the impact of his work as a judge, including the Grand Bohemian Medal and an honorary doctorate of laws from this university. And he also teaches law and is an honorary professor of the law faculty here. We all know that Justice Bokhary is well known for his dissenting judgments and that he has a great passion for the rule of law and its application in a democratic society. And now with this new book that he has just published, Human Rights, I think we can say that he also stands out as a champion of human rights as well. Justice Bokhary first came to the Law Library in 2014. At that time, we first launched our book talk in the Law Library, and also he published his light reading books, including The Law is a Crocodile, Crocodile at Law, and also his memoir, Recollections. Last September, he was here as an invited guest to speak in the program Chamber Chats with the Judges, which we co-organized with the General Education Unit. And I'm particularly excited to welcome him back for the third time round. So thank you for speaking to us today. So please join me now in welcoming Justice Bokhary.
Human rights, as I see them, represent the minimum which people everywhere are entitled to demand for themselves and must accord to others. Why? So that we may all live and let live with human dignity, while enjoying the maximum personal autonomy consistent with life in organized society. Unified by principles of justice, these entitlements involve, as I see them, civil liberties, personal security, security of property, however modest, self-expression, public participation, respect for otherness, education, healthcare, and at least a tolerable standard of living. These, duly enforced, enable each and every one of us to be ourselves and to live and let live with human dignity in how we treat others and are treated by them. Such fundamental rights and freedoms are inherent in the human person. The best judicial statement of this natural law view of human rights is that of Judge Tanaka in the International Court of Justice, where in the Southwest Africa case, His Excellency said that the state cannot create human rights, but can only protect them, for these rights have always existed with human beings independently of and before the state. Going back to the 19th century, we find Chief Justice Marshall of the United States Supreme Court saying in Ogden and Saunders, decided in 1827, that the right to enter into contracts is anterior to and independent of society, and was, like many natural rights, brought with human beings to society. By going back even further to the Court of King's Bench in the 17th century, we find Sir Edward Coke saying in Calvin's case, decided in 1607, that the allegiance which people owe to their sovereign and the protection which their sovereign owes to them are due to the law of nature, which was long before any judicial or municipal law. To these classic judicial statements, let us add a classic theological one. In the 13th century, St. Thomas Aquinas went so far as to say in Summa Theologica that if human laws deviate from reason, they have the nature not of law, but of violence. Back to the law, but still with the classics, let us look at a 16th century one, this being Christopher St. Germain's Doctor and Student, where he says that the law of nature is written in every human heart, teaching us what is to be done and what is to be fled. And that any prescription, statute, or custom contrary to this natural law would be void. These are the ideas in which you will find the roots of entrenched human rights, enumerated in constitutions, safeguarded by independent judiciaries. The Universal Declaration of Human Rights was proclaimed by the General Assembly of the United Nations in 1948. In 1966, the General Assembly adopted the International Covenant on Civil and Political Rights, the ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, the ICESCR. These two covenants entered into force in 1976. Together, the Universal Declaration and these two covenants form the International Bill of Rights. And what is thus protected internationally is protected by constitutions domestically. So you see, in the aftermath of the Second World War, which took so many human lives, and during the Cold War, in which the threat of thermonuclear destruction hung so closely over the world, humankind put its faith in the enforcement of human rights as the surest way to achieve a just world order. and thereby world peace. What are the widely recognized human rights? Well, if you go by the ICCPR, and it's acceptable to do so, civil and political rights consist essentially of right to self-determination, freedom from discrimination, right to gender equality, right to life, freedom from torture, from inhuman treatment, and from experimentation without consent, freedom from slavery and servitude, liberty and security of the person, rights when deprived of liberty, freedom from imprisonment for debt, freedom of movement, rights of aliens to protection against arbitrary expulsion, right to procedural guarantees in civil and criminal cases, freedom from retrospective criminal laws, right to recognition as a person before the law, right to privacy, freedom of thought, conscience, religion, and belief, freedom of opinion, expression, and to information, freedom of assembly, freedom of association, and to form and join trade unions, rights in respect of marriage and family, rights of children, right to participate in public life, right to equality before the law and equal protection of law, rights of minorities. Going by the ICESCR, again, I think legitimate to do so, socio-economic rights consist essentially of right to work, right to just and favorable conditions of work, right to form and join trade unions, right to strike, right to social security, including social insurance, right to an adequate standard of living in terms including food, clothing, and housing, right to continuous improvement of living conditions, freedom from hunger, right to the highest attainable standard of physical and mental health, right to education, right to take part in cultural life, right to benefit from scientific progress, authors' rights, and freedom of scientific research and creativity. Now, I've spoken of rights being inherent in the human person. So you might ask me, well, what about the right of abode? My answer is this. With the advent of the nation state, the right of abode is the residue of the original and inherent right of each and every human being to inhabit the earth. Human rights are, you will find in Article 5 of the Vienna Declaration of 1993, universal, indivisible, interdependent, and interrelated. They are to be viewed, they must be viewed holistically. Calling civil and political rights first-generation rights, calling socio-economic rights second-generation rights, and calling group rights third-generation rights, merely reflect, and as such are harmless, the order in which they gained recognition. But ultimately, all human rights come together. Moving now, if I may, from source and content of human rights, let us look at their enforcement. Internationally, they are protected both under customary international law and under treaties. Their domestic application is both horizontal, as between private persons, and vertical, as between people and governments. They are protected by constitutions, by statutes, by the common law, and by administrative measures. Judicial remedies are given in order to protect them. In our jurisdiction and similar jurisdictions, constitutional adjudication includes what we call constitutional review of statutes, of the common law, of administrative measures, of whatever is provided and whatever is done, or whatever somebody with a duty to do refuses to do. In such jurisdictions, ours and others, the term judicial review, of course, is used to what pertains to administrative law. But of course, the most famous term for constitutional review, as I've called it, is of course judicial review, laid down by the United States Supreme Court in Marbury and Madison. And if ever a more important judicial decision has ever been given, I'll be very glad to hear what it is. Now, let me take the right to life as an illustration of human rights in action. Having listed out so many fundamental rights and freedoms, obviously impossible in the time available to deal with all of them in depth. But I take the right to life because it is a good illustration of human rights in action. First of all, it is a civil and political right, but it opens the way for enforcing certain socio-economic rights. The right to life comes within the irreducible core of human rights. It is non-derogable even in a national emergency. But what is its true content and how does it operate? In doing so, I will look at jurisdictions apart from our own. Comparative law I regard as highly important. Not easy. A noted legal anthropologist said that there were thousands of legal systems in the world, of which we have fairly detailed information about several hundred. So all of these things that I say are illustrative, taken by way of example. Let us start with war. Aggressive war is, the Nuremberg Tribunal said, the supreme international crime, differing from other war crimes in that it contains within itself the accumulated evil of the whole. The Universal Declaration seeking world peace through human rights came, let us not forget, in the aftermath of a world war which, if you include deaths by war-related starvation and war-related diseases, which claimed over 80 million lives. Genocide, ranking close to war, aggressive war as a denial of the right to life, in many ways particularly ugly too. Preventing genocide remains a struggle throughout the world. You never know when prejudice spills into discrimination, and when discrimination grows and grows and grows until it becomes genocide. What about the death penalty? How does that stand in relation to the right to life? The death penalty is exacted by some nations, but not by others. In some nations, certain parts exact the death penalty, while others do not. Thus, there are some states of the United States of America which have the death penalty, while others do not. And in our country, the mainland does, while Hong Kong does not. Article 6.2 of the ICCPR provides that in countries which have not abolished the death penalty, sentence of death may be imposed only for the most serious crimes. Among the offenses punishable by death in the mainland is corruption. In some of our neighboring countries, the crimes punished by death include drug-related crimes. Does any of this reflect a view that the death penalty is appropriate even for crimes other than the most serious ones? Not necessarily. It may be a matter of what crimes are considered to be in the most serious category, having regard to the circumstances of the jurisdiction. Fortunately, and I make no apology for underlining fortunately, the worldwide trend is generally towards the abolition of the death penalty, or at least a more limited use of it. The arbitrary deprivation of life stands against the right to life in the most obvious way. And as a deterrent against the arbitrary deprivation of life, the right to life calls for the certainty of effective official investigation into any death due to the use of force by military or law enforcement agents of the state. What about euthanasia? One argument in the ongoing debate on euthanasia is that in certain circumstances, a person has the right to die, so that in assisting her or his suicide, one should not be treated as having committed a crime. Well, not many jurisdictions permit assisted suicide, but just because assisted suicide is not permitted, it does not compel doctors to maintain life support of patients who are beyond cure, suffering terribly, and incapable of indicating whether they wish to live or die. There was a case, Airedale National Health Trust against Bland, which came before the House of Lords in 1993. And Lord Gough acknowledged that it can be asked why doctors who may lawfully let their patients die by discontinuing treatment may not lawfully put their patients out of their misery straight away by lethal injection. These are the sort of questions which the debate on euthanasia, and indeed the debate on the right to life generally, raise. They are troubling questions. they do not accord with everybody's convictions or religious belief, ultimately society will take a secular view. And it is often the case that one might have to uphold the law contrary to one's religious belief. It is part of, maybe, respect for otherness, if you like. What about abortion? Again, a quite emotional topic. The United Nations Human Rights Committee is against totally banning abortion, also against restricting its purpose only to saving the mother's life. Hong Kong law permits abortion for purposes wider than that. I think I would describe our law as neither wholly pro-choice nor wholly pro-life, and it embraces, if you study it, some notion of an unborn child's right to life. Self-defense, well, at common law, and perhaps under many other systems apart from common law systems as well. Killing is not criminal if done by anyone acting reasonably in defense of self or others, or by a law enforcement officer using reasonable force to make an arrest or protect the public. So let's come to the question, crucial to the right to life, of whether innocent life can be taken to save life. On this question, we can begin, I think one always must begin, with the English case of the Queen and Dudley and Stevens, decided in 1884. This is a case which has been of influence throughout the common law world. A ship sank, 4 persons took to a lifeboat. There came a time when they were close to death. And at that point in time, the master Dudley and the mate Stevens killed the weakest of the 4, cabin boy named Parker. They and a crewman who, by the name of Brooks, who had not taken part in the killing, fed on the boy's body, drank his blood, and survived to be rescued, believing, as many people seem to have done at the time, that their conduct was warranted by a custom of the sea. Dudley and Stevens gave frank accounts after rescue of what they had done. They were tried at assizes for murder. The trial judge took an unusual course. Instead of taking from the jury a general verdict of guilty or not guilty, he took from the jury a special verdict setting out all the facts. Those facts were then laid before a 5-judge panel of the Queen's Bench Division, presided over by the Lord Chief Justice. The panel held that it was murder. Dudley and Stevens were sentenced to death, but by then, and even a little before then, public opinion had swung very firmly in favor of Dudley and Stevens, or at least sympathetically towards them. One factor might have been that it was widely reported in the press that when the case was before the magistrate at the committal proceedings, the cabin boy's brother, who himself was a seaman, had turned up in the magistrate's court and had shaken hands with Dudley and Stevens and Brooks. Anyway, Dudley and Brooks turned Queen's evidence, so he wasn't tried. Dudley and Stevens, who were convicted of murder and sentenced to death, had their sentences commuted to 6 months imprisonment. We come now to a case which goes by the name of Re-A, Children, Conjoined Twins, Surgical Separation. It is a case, the name of which tells you what the case is about. 2010, twin infant girls were conjoined at the pelvis. Through a shared artery, the stronger twin was oxygenating blood for both twins. If they were not surgically separated, the weaker twin was likely to die before the twins reached 6 months, and that would certainly have resulted in the death of the stronger twin as well. Surgical separation would have given the stronger twin a good chance of survival, but would kill the weaker twin at once. The parents felt unable to let one of their daughters die in order to save the other, but the doctors favored surgical separation. The National Health Trust concerned sought a declaration that surgical separation would be lawful. The High Court made, and the Court of Appeal affirmed such a declaration. Dudley and Stevens' case was distinguished. Surgical separation was performed. The weaker twin died at once, but the stronger twin lived. Now, some people say, and just about any view in such a painful case is reasonable, that the decision should have been left to the parents. Maybe so. I assure you that I would not have relished such a decision as a judge. And I don't think any one of you, if you end up on the bench, would relish having to take such a decision. But if I took the decision or you took the decision, the one thing that would emerge is this, that at least, if nothing else, we would have spared the parents from making a very painful decision. And that's what happened. And that is a case in which, admittedly under very special circumstances, an innocent life was taken to save another innocent life. There is a duty to protect the right to life. There are a great number of duties that the state is, I think, under, some more well recognized than others. One of them is to prevent infant mortality, in connection with which socio-economic rights are highly important. Now let me tell you of now the case of Shelazir against Wapta, which was decided by the Supreme Court of Pakistan in 1994. In this case, the Supreme Court enforced the socio-economic right to live in a clean environment. And they did it by first holding that this socio-economic right was included in the civil and political right to life, and two, by devising innovations of process and remedies to secure it. What had happened was this. People said that there was a power station from which there might be emissions of electromagnetic impulses injurious to health. And the case came before the Supreme Court by way of a constitutional petition. Now, courts of last resort, as in Hong Kong, receive cases subject to some limited leapfrog procedure through the channel of appeals. And that's quite typical. Some constitutional courts, the South African Constitutional Court, a very great tribunal, the Bundesverfassungsgericht, a very great tribunal, are courts of first and last resort, as indeed the European Court of Human Rights is. Some courts combine both. Supreme Court of Pakistan's one, Supreme Court of India's another. Normally they hear appeals in the ordinary way, but in cases of urgency, they can take a constitutional petition directly. And if you write a postcard to the Supreme Court of India and you say something substantial, they will turn your postcard into a writ petition for you. Now, the disadvantage of this is that the facts are not found. So the first thing that the Supreme Court had to do is to say that although the Constitution doesn't enumerate a right to live in a clean environment, it does enumerate the right to life, and the right to life, they say, includes the right to health, and the right to health includes the right to live in a clean environment. Therefore, through that civil and political right, they reached the socio-economic right. And as far as procedure is concerned, the innovation of procedure, they said, well, the government cannot carry out any of these projects without a public consultation, and for the purpose of these public consultations, the government's obliged to set up an independent scientific commission to report on the matter. In the case of Olga Tellis against Bombay Municipal Corporation, decided by the Supreme Court of India in 1985, the Supreme Court held that the socio-economic right to an adequate means of livelihood, which was not enumerated in the Constitution as a justiciable right, is an important facet of the civil and political right to life, which is enumerated in the Constitution as justiciable. The case involved pavement dwellers. Unless they came to the urban environment, they couldn't find work. In the urban environment, they had no place to stay except to sleep on the pavements. The city was seeking to remove them. The Supreme Court put some restrictions on what the city could do in that regard and ordered prioritization of arrangements for these people. Now, human rights, I say, must always move forward because, as Mrs. Eleanor Roosevelt herself, the great architect of the Universal Declaration and the great inspiration of the two covenants, said, that this is preeminently a field in which to stand still is to retreat. Now I say a word on democracy. Most regrettably, discontent has spilled into violence in the streets. Democracy is itself a human right. Indeed, the United States Supreme Court said in Westbury and Sanders, decided in 1964, that other rights, even the most basic, are illusory if the right to vote is undermined. How are people to pursue their aspirations? In a democracy, they do so principally through the electoral process. And our Constitution, the Basic Law, intends that Hong Kong shall be a democracy. As to the Legislative Council, we all know that Article 68 provides that the ultimate aim is the election of all members by universal suffrage. And as to the selection of the chief executive, we all know that Article 45 provides that the ultimate aim is likewise such selection by universal suffrage upon, it is said, nomination by a broadly based nominating committee in accordance with democratic procedures. Well, by the specific wording and by the very nature of what we are dealing with, I have no hesitation in saying that it is blindingly obvious that the nominating committee is meant to serve the ultimate aim of universal suffrage, not to impede it, undermine it, or in any way deny it. And this understanding informs how the committee should be formed and how it should function. Pending the attainment of democracy here, the courts will deliver human rights as far as they can in the absence of democracy, remembering what was said in that case that I just quoted. If and when, a few years ago, I've never said if and when, I would have just said if and when. Would I have said if and when? I would have said when. But now I have to say if and when. But I still wish to put the emphasis of when. Hong Kong attains democracy. Then will the one country, two systems principle, declared in the preamble to the Basic Law, be fulfilled. And then so will be fulfilled the promise of a high degree of autonomy, which promise is made in Article 2 of the Basic Law, and which promise is an integral part of that principle. Up to and beyond the 30th of June, 2047, my faith rests on the one country, two systems principle and on you. I don't know if I'll be here to see what you can do in 2047. On the 30th of June, I still won't be 100, I'll only be 99. But in spirit, at least, I will be with you. Thank you.
Thank you, Judge, for your very inspiring speech. Please take a seat. I will now have around 10 minutes Q&A section, and followed by book signing session here. If you wish to get a copy of Justice Bokhary Human Rights, you can purchase your copy at the entrance after the Q&A section. So the floor is now open for questions.
Thank you, Justice, for your speech. I learned a lot from that. As you mentioned about the possibility of violence in Hong Kong recently, may I ask a question about civil disobedience? So if there is someone who is admittedly performing such an act to break the law and he's now before the court, what would the court do, or is there any difference of him from an ordinary offender? Like, would the court consider his moral reasons for breaking the law, and how would this be considered? Thank you.
Now, I don't wish to answer the question too specifically because there are cases pending before the court. And of course, it's not beyond the realms of possibility that something might reach panel of the Court of Final Appeal in which I happen to be sitting. But the examples are there around the world to see. The suffragettes, civil rights, anti-apartheid. Various independent movements. Mr. Gandhi was the prime proponent of civil disobedience. Mr. Jinnah believed wholly in constitutional methods and would not breach even the letter of the law. All I can say in general terms is that the law is not blind to circumstances. But beyond that, I say nothing for fear of prejudicing pending cases.
Anyone?
Thank you, Justice. Okay. How would you comment on Hong Kong Court judicial's protections for economic social rights? Do you think that the court should be more active in resolving matters that might involve government economic policy or social policy?
Well, there's a long answer and a short one. The short one is yes. The Swiss Supreme Court was very realistic when it recognized that courts are not ideally equipped to deal with some of the policy issues which arise, but said that if people are denied their basic constitutional rights, the courts will intervene. I think that if there is the will to advance socio-economic rights, the way is there. Look at what the Supreme Court of Pakistan did in the case that I cited. Look at what the Supreme Court of India did. And there was a decision of the South African Constitutional Court. 40,000 homeless persons had occupied a private property owner's land. The land wasn't in immediate use, and the landowners sought the court's assistance to evict these 40,000 people. The court said, well, why should we do that? There's a constitutional right to housing. These people have no home apart from the one that they have set up in this private owner's land. So we're not going to evict them. But we're not going to let the private landowner suffer either. The government has a constitutional duty to house these people. They're on this land because the government hasn't done its duty. So what we're going to do is that until the government houses these people, and as long as they're on this land, we will make the government pay rent to the private landowner. So I think that you have to be innovative about these things. Because otherwise you're just making statements, oh, it's so important, so on and so forth, and then say, well, all right, so what? It's all very difficult. But if you really mean to, and I think the courts should be looking for ways to do it, Do you know, I used to travel around the world, and very proud of the fact that I came from this sophisticated jurisdiction, Hong Kong, and I'm still quite proud of it. But the more I travel, the more I learn that we have a lot to learn from other jurisdictions.
Thank you, Justice, for sharing. You have just shared about how to balance between the right of life of one innocent person with another one. What I have in my question relates to the general issues of terrorism, as to how should the court balance the life between the right to life of the general public and the right not to be tortured. Thank you.
I think that we better not draw any balance at all. We should just set our face against torture. Because once you begin to use this, you never know where it's going to go to. And ultimately, to be perfectly frank, if I thought there was a bomb planted somewhere in some school in Hong Kong, including, let's put it this way, selfish, my own grandchildren might be, I suppose I would, without thinking about it, say that let's torture the man for the information as to where the bomb was. But supposing he won't, and we could get hold of his children, would we torture his children in front of him to get the answer out? Do you know, I would hate to be a murder victim, but if it really came to it, I'd rather be a murder victim than a murderer, to be perfectly honest. And when Mr. Gandhi was raising subscription to erect a monument to the people slain at Jallianwala Bagh, he said that this will not be to commemorate, if I have anything to do with it, the evil deed, but it will serve as a reminder to the nation that it is better to die unarmed and helpless than to be an oppressor. So ultimately, there comes a time when you just have to say no.
Could we have the last one or two questions? At the back.
Thank you. Good afternoon, Justice Bokhary. You mentioned you put faith in the one country, two system, and that you built. Hello, is this working? It's working. And that the nominating committee is set up to facilitate democracy rather than to undermine it. There would be a lot of people who would disagree with you on that. And in fact, a lot of people these days, youngsters mostly, would think that the nominating committee is democracy in form rather than substance. I mean, like, surely you as a retired judge of the CFA would have a more sort of understanding of the system. But how should we as youngsters put faith in one country and two system when the government, the central government indeed, conception of democracy in substance is to put, say, substantial representation of the fishery and agricultural sector in the nominating committee, and indeed the functional constituency, and bearing in mind that there are revolving discourses on that Hong Kongers are deprived of the right of self-determination in the 1989 negotiations. I mean, it's a pretty long question, but my question in short is, like, how do we reconcile differences in that, whether one country and two system is different views in the one country and two system, I suppose.
Well, if you ask me whether I would rather that the provision for a nominating committee wasn't there, of course I would, but it is there. And there seems to be no prospect of getting rid of it. So the only thing that one can do is to work out, sincerely if one can, a means by which the nominating committee is selected in such a way which is itself democratic, and that it should operate in a way which is democratic. Frankly, once you select it in a way that's democratic, it can't actually function any way other than democratic. I suppose there is anxiety on both sides of the question. I suspect that the central government is concerned as to what will happen if the people of Hong Kong are entitled to pick a chief executive without any sort of vetting whatsoever. If this is a lack of faith in the people of Hong Kong, it's no use just railing against it. One must attempt to accommodate it. I don't actually think that people of Hong Kong would elect a woman or a man to the office of chief executive simply in order that she or he will spend the whole time arguing with head office. That is not the way. And nobody would actually ultimately choose such a person. And the problem now is that there seems to be a certain lack of trust of the common people of Hong Kong. Some elements of the population react strongly. This creates further mistrust, and so it spirals downwards, which is very unfortunate. But if we can sit back and just think about what a stable and sensible population we have, and the people are trusted, then I think it can work. One country, two systems is not of our own invention. It was invented in the mainland because the interests of the whole nation was seen to rest in a special arrangement for Hong Kong. So my faith is shaken, but not destroyed. How do I feel about some of the things that I see around me? Well, you know, Abraham Lincoln once lost an election, not a very important one perhaps, but it was important to him at the time, and he was asked how he felt. And he said, well, I feel like the young fellow who was running through the woods barefooted to go and see his sweetheart. And he stubbed his toe against a log. And when he was asked how he felt, he said he was too big to cry and too badly hurt to laugh. And I suppose that's what we are, actually. We are. Although I've just laughed. I think we are too badly hurt to laugh, but we are too big to cry. So let's just get on with what we can do. It's not going to be easy. And if you ask me how we're going to get out of this, I don't know, except Hong Kong has gotten out of so many difficult situations in the past that maybe we can get out of this one. All I can say is I'm with you. I'm not going anywhere.
Sorry, I have the very last question here.
Okay. Sure. Yeah, follow mine.
Justice, I understand that there have been a lot of exchanges between governments, Hong Kong and also their counterparts in mainland before and after 1997. Just interested to know whether that has also taken place in respect of the judiciary.
Well, the judiciary operates independently and openly. So the exchanges that we've had would be purely academic. I did myself lead a delegation of Hong Kong judges up to the mainland to attend some lectures on the mainland law, just to familiarize ourselves with the law on the mainland. And there was nothing wrong with that, because mainland judges come to Hong Kong to learn about our laws. But there came a point in time when the basic law arose, and there was a suggestion that we'd receive a lecture on the basic law, and I said that I would not agree to that. Because the basic law may be a national law, but it is a law which has application only in Hong Kong. It's our constitution. And I said that I was prepared to have a seminar on it, and that there would be mainland participants in the seminar and Hong Kong participants in the seminar. So that's how I think we do these things. And done that way, I think it's healthy. But everything in the courts is done openly. You can see it. What you see is what you get. Whether you like it or not, it's there. Thank you.
Sure. I've got two questions. First of all, what's your view on call for independence in Hong Kong? Whether mere advocacy for independence in Hong Kong, in your view, is that against any law, or whether that's a fundamental human right? And secondly, some judges have been criticized by some sectors of society for giving what some see as lenient sentence to pro-democracy activists. What's your view on these criticisms?
Well, you know, if it's said that a judge has passed too lenient a sentence, there's a way of doing it. You can have a look at it. The judges are not necessarily always right, and there is a procedure. But I think a political sort of move to get judges to pass more severe sentences by reference to some political ideology of the people pressing for it is wrong. Now, as far as what Wong Chun-man said, I know his father-in-law very well, a very fine gentleman who was a true patriot and believed in the one country, two systems principle and understood it. And Chun-man is a friend of mine as well. I would be very sorry to get into a public quarrel with him. But this is something that I would like to talk to him about. Ultimately, however, whether people are prosecuted for any actions in Hong Kong is decided by the prosecuting authorities of Hong Kong. And if a prosecution is brought, what happens to that prosecution is in the hands of an independent judiciary. And my faith has always been the judiciary, even when I predicted, maybe too mildly, about some of the clouds on the horizon. I said that if the storm breaks, the judiciary will stand in that storm. I suspect at that time when I said what I did, some people thought I'd put it too high. I suspect a lot of people now think I put it too low. But high or low, the judiciary will stand in whatever situation we have to face. I bid you have faith in our judges. Thank you. Oh, I see. Well, as far as independence is concerned, my faith is in the one country, two system principle. As a judge, I've taken an oath to affirm, to uphold the basic law, of which Hong Kong being part of China is a principle. And even beyond 2047, my personal faith is in the one country, two systems principle. But just because you disagree with somebody, and just because you think his views are dangerous, if you think it's dangerous, doesn't mean you deny his right to speak about it.
Thank you very much, Justice Bokhary. So we're now having book signing section. For those who have got Justice Bokhary books, you come out. And for those who wish to buy his latest title on human rights and also his other publications, there is a desk at the entrance which you can make your purchase.